Good afternoon. Thank you for joining me. I'm Richard Livingston, a barrister at King's Chambers, specialising in clinical negligence work. The webinar today aims to look at the case of Hughes and Rattan and consider the practical implications of the case. We'll all be familiar with the case's ratio and most likely the obiter observations. However, it's worth looking at the case in some detail so that we know where it takes us and how, if at all, it can be distinguished. This webinar focuses, however, on the strategies to be deployed when defending dental cases. 4 issues I'm aiming to cover: what general principles can be gleaned from Hughes, what, if any, is the relevance now of the defence of vicarious liability? Thirdly, can you still challenge the principle of non-delegable duty? And when and how should you seek contribution from other parties? In Hughes, the claimant alleged that she had received negligent treatment from 3 associate dentists and 1 trainee dentist operating out of a dental practice owned by the defendant, Mr. Rattan. Mr. Rattan had contracted with Bromley Primary Care Trust to provide NHS dental services. A claim was brought against Mr. Rattan only, who had not treated the claimant himself. The background facts were largely agreed and are thoroughly summarised within both the High Court and Court of Appeal judgments. In brief, the defendant had a general dental services contract with the PCT. He was paid a set amount by the NHS for providing an agreed number of dental services. He was permitted to subcontract those services. He had to comply with certain standards to check the training and qualifications of the associates and check their insurance. The associate dentists were retained on a standard British Dental Association contract. The defendant provided the premises, equipment, reception staff and nurses, and the associate dentists were paid 50% of the fees received by the defendant from the NHS for the treatment they provided. They held their own insurance. They were responsible for their own tax and national insurance. They were not entitled to sick pay or pension contributions. They had minimum hours, had clinical control over the dental treatment provided, and could work elsewhere if they wanted. Crucially, however, the so-called goodwill of patients of the practice was retained by the defendant. In other words, the associate dentist could not leave and take their patients with them. An issue arose between the parties as to whether the claimant was a patient of the practice. The claimant said that she made appointments at reception, that she didn't choose a particular dentist, and that she paid at reception. As far as she was concerned, she thought that she was a patient of the practice. The defendant's case was that she could request a particular dentist, but otherwise would be allocated her usual dentist or another if not available. The trial of a preliminary issue was directed and defined in the way that we see on the slide, namely whether the defendant is liable for the acts or omissions of the treating dentist by virtue of vicarious liability or a non-delegable duty of care. At first instance, stripped to its barest essentials, it had been held that there was a non-delegable duty of care owed by the defendant to the claimant, and that although it was not necessary to make that finding, the defendant was vicariously liable for the alleged negligence of the associate dentists. Turning first to the issue of non-delegable duty of care, at first instance, the judge had referred in detail to the 5 factors identified by Lord Sumption in Woodland and Swimming Teachers Association. The argument centred on factors 1 to 3. The defendant conceded that 4 and 5 would apply to the case. And Lord Sumption's 5 cumulative factors were as follows. Firstly, the claimant is a patient or a child, or for some other reason is especially vulnerable or dependent on the protection of the defendant against the risk of injury. Other examples are likely to be prisoners and residents in care homes. There is an antecedent relationship between the claimant and the defendant, independent of the negligent act or omission itself. One, which places the claimant in the actual custody, charge, or care of the defendant, and 2, from which it is possible to impute to the defendant the assumption of a positive duty to protect the claimant from harm, and not just a duty to refrain from conduct which will foreseeably damage the claimant. It is characteristic of such relationships that they involve an element of control over the claimant, which varies in intensity from one situation to another, but is clearly very substantial in the case of school children. And thirdly, the claimant has no control over how the defendant chooses to perform those obligations, i.e. whether personally or through employees or through third parties. Fourthly, the defendant has delegated to a third party some function which is an integral part of the positive duty, which he has assumed towards the claimant, and the third party is exercising, for the purpose of the function thus delegated to him, the defendant's custody or care of the claimant and the element of control that goes with it. And finally, the third party has been negligent, not in some collateral respect, but in the performance of the very function assumed by the defendant to him. The defendant's first ground of appeal was that the judge's conclusions on non-delegable duty was wrong, and that she had wrongly found that factors 1 to 3 were satisfied. The defendant argued that the circumstances in Hughes were very different to the hospital cases considered in Woodland. And they phrased the appeal in this way, that unlike a hospital accepting a patient, when the practice was contacted by the respondent and agreed to make an appointment with the dentist, it didn't assume a duty to the respondent to provide dental treatment, but merely a duty to make arrangements for the dental treatment to be provided by an associate. And secondly, unlike a hospital, the appellant had no care or control of the respondent in respect of the dental treatment that was ultimately provided. Any care or of control was limited to the administrative functions carried out by the practice. So the defendant's argument focused on Woodland Factor 2. It was said that the interactions with the practice were purely administrative. And as such, there was not a relationship which placed the claimant in the actual custody, charge, or care of the defendant. And the defendant relied upon the case of Arms in Nottinghamshire County Council and the distinction drawn in that case between a duty to perform on the one hand and a duty to arrange for care to be provided on the other. The defendant also cited the case of Child and Ministry of Defence as approved by Lord Sumption in Woodland. And the defendant submitted that its duty in this case was merely a duty to arrange the care, an argument which you would think on the face of it carried a great deal of force. It was accepted, though, that if Woodland Factor 2 was fulfilled, Factor 1 would most likely follow. As in Factor 3, the defendant referred to Great Britain and the Home Office and relied upon the fact that the claimant could choose which practice she attended. Lord Justice Beam upheld the judge's decision and reasoning on non-delegable duty of care. it was right, he said, to say that the claimant was a patient of the practice, not just in layman's language, but crucially as a matter of law. Of particular significance was the fact, as he saw it, that there were restrictive covenants under which the practice retained the goodwill of patients of the practice. And he addressed the woodland factors in the following way. And he said that he considered that the judge at first instance was right to find that the claimant satisfied all the factors identified by Lord Sumption at paragraph 23 of Woodland, as giving rise to a non-delegable duty of care. Firstly, he said in relation to the first factor, and this is an important point, that he considered that patient must include anyone receiving treatment from a dentist. He said that there was nothing to suggest that Lord Sumption had used the term patient in the old sense, that's to say someone who lacks capacity, who would nowadays be categorised as a protected party. Nor, he said, is there anything within Lord Sumption's judgment to suggest that the term is confined to accident and emergency patients, or indeed to those who are inpatients. Whether it includes medical or dental patients who are not actually subjected to treatment, but merely advised in consultation, he said, is a question for another case and another day. He said, but the sentence in the judgment cannot be rewritten as though the claimant had to be within a subset of especially vulnerable patients in order to qualify. Turning to the second factor, he said that there was an antecedent relationship between the claimant and the defendant, which was established at the latest on each occasion when the claimant signed the personal dental treatment plan. And I'll come on to deal with the significance of that document once I've summarised the outcome in Hughes. He noted that the claimant in the Hughes case was required to do this before any NHS treatment was carried out. And he felt that that relationship placed the claimant in the actual care of the defendant, not because he was a dentist himself, but because he was the owner of the practice. It would have done likewise if the practice had been run by a company or owned by a partnership. The duty, as Lord Sumption said in Woodland, was on account of the antecedent relationship personal to the defendant. And he said that the duty owed by Dr. Rattan was a positive or affirmative one to protect the patient from injury, not simply to avoid acting a way that foreseeably causes injury, and it involved an element of control over the patient. As for the third factor, he said that the claimant had no control over how the defendant chose to perform his obligations, whether personally or through employees or third parties. She could express a preference as to which associate she'd like to see, but no more than that. Of course, she had control in the sense that she could refuse to be seen by anyone other than Dr. X, or could refuse to be treated at all. But he said that applies to all dental patients and all hospital outpatients, at any rate those with full capacity. So having dismissed the appeal on non-delegable duty of care, the Court of Appeal, as we know, didn't strictly need to deal with the second ground of appeal, but were asked to do so because Hughes was treated as a test case. The defendant appealed this aspect of the decision on the grounds that the judge had failed to consider or give appropriate weight to relevant factors when concluding that the relationship was akin to employment. The claimant argued in response that the judge had made an evaluation of the facts and that, in essence, the defendant was seeking to re-argue the case on the facts, which it wasn't permitted to do so on appeal. The judge at first instance had considered and referred to the leading modern authorities on vicarious liability, including the Barclays Bank case, and regarded the critical question as being the one asked by Lord Reid in Cox and Ministry of Justice, that is, whether the alleged tortfeasor could be said to have carried on activities as an integral part of the business activities carried on by a defendant and for its benefit, rather than his activities being entirely attributable to the conduct of a recognisably independent business of his own or of a third party. If that had been the last word from the Supreme Court on the issue, Lord Justice Beam would have upheld the judge's findings, essentially for the same reason which gave rise to his finding that a non-delegable duty of care was owed. However, following Barclays, the critical question now appeared to have reverted to being whether the alleged tortfeasor's relationship with the defendant can properly be described as akin or analogous to employment, with the focus being on the contractual arrangements between the tortfeasor and the defendant. The relationship in Hughes did not satisfy the Barclays test, and the Court of Appeal referred to various factors, in particular, the fact that the associate dentists were free to work as many or as few hours as they wished, and that they were also free to work for other practice owners and businesses, and in fact, some of them did. And secondly, the defendant had no control over the associate's clinical judgment in terms of financial arrangements. They took sole responsibility for tax and national insurance and were regarded as independent contractors by HMRC. And each held their own professional indemnity insurance and met their own expenses for equipment which was not provided by the practice. While there were factors which pointed the other way, the Court of Appeal didn't consider these factors to be determinative, and in the circumstances agreed unanimously that the issue of vicarious liability did not arise. Having said they agreed unanimously as a slip of the tongue, in actual fact they didn't. Lord Justice Beam differed from the other judges on the issue of vicarious liability. But this was, of course, of little assistance to the defendant, given the earlier findings on non-delegable duty of care. So perhaps unsurprisingly, both sides have proclaimed the outcome as a win. Nevertheless, both sides would surely agree that the case makes it clear that the duty owed to dental patients cannot readily be distinguished from that owed to medical patients more generally. Claimants can now bring a more straightforward claim against a practice owner, as many of them have already been doing, where, as is often the case, there has been a course of treatment of various dates by various practitioners, or where associate dentists may have insufficient or non-existent insurance cover. Of course, it will still be appropriate to join named dentists individually in certain cases. For example, in cases where the practice insurance cover may not respond, or where there may be concerns regarding whether there's a non-delegable duty in your particular case. The case of Hughes is interesting, I would suggest, in two major respects. Firstly, it establishes a relatively low bar for establishing a non-delegable duty. And I say that for the following reasons. Firstly, for the purposes of establishing the first Woodland factor, all that's required is for the claimant to be a patient undergoing treatment. Secondly, there's no additional requirement for any special vulnerability. Thirdly, the existence of an antecedent relationship may be satisfied by the existence of a contract to provide medical care. And fourthly, the ability of a patient to choose which of the defendant's practitioners should treat them doesn't negate a non-delegable duty of care. And ultimately, the court will step back and ask itself whether, on the facts and the contracts between the parties, the claimant was a patient of the defendant. But secondly, it provides a relatively high bar for establishing vicarious liability. It's not sufficient to prove that a negligent practitioner was working as an integral part of the defendant's business, nor that they were not in business on their own account. The correct focus is upon whether the relationship between the practitioner and the defendant is akin to employment. Now, there are no bright lines. The answer will depend on an open exercise of evaluative judgment. The features of the relationship that resemble employment will go on one side of the scales. The features that do not resemble employment will evidently go on the other side. And then the court has to decide whether the scales tip towards employee or independent intractor. However, following a decade of rapid progression, this case is surely the latest example of judicial restraint in the application of vicarious liability. What is the decision's impact on the wider healthcare sector? Well, I would suggest that the decision is likely to have ramifications for providers in the wider healthcare sector. We could see far more of these cases being pursued as the private sector plays a role in COVID recovery. The outcome, of course, is likely to depend on the precise structure of the relationship. Cases where the hospital providing the facilities is the only legal body with adequate insurance cover, because, for example, the surgeon is inadequate or no cover at all, could be under the spotlight once more, as in the Spire and RSA litigation or in the Patterson litigation. Judgment is also due from the Privy Council in the case of Gulf Hugh Medical Sector and Tashira imminently. I remain puzzled as to why claimants proceed against practice owners only. I'm sure we all do, except in cases, of course, where there's a real concern that an associate is either uninsured or, for whatever reason, their policy of insurance is unlikely to respond. In a recent case that I was involved in Bristol, the designated civil judge explicitly said during his judgment that he was at a loss as to why the claimant had not named the associates as defendants. For defendants, of course, and most practice owners now need to be aware of the implications for their own insurance cover. The insurance position of associate dentists needs to be scrutinised, as practice owners should still be entitled to indemnities from them. But in practical terms, what advice do we give to clients to avoid a finding that as practice owner they owe the non-delegable duty of care? Is this still a realistic possibility? Well, I think that it is. In Hughes, as I mentioned, the judges took into consideration the claimant's own perception that she was a patient of the practice rather than the individual dentist who treated her. The personal dental treatment plan form used in England and Wales was significant in relation to this point, as this named Dr. Rattan as the dentist providing her treatment. Furthermore, the claimant had not received any other documentation naming the individual dentist, and it was identified on all the documents and before the court that she was a patient of the practice under the associates agreement. In Woodland, Lord Sumption made it clear that the imposition of a non-delegable duty of care was an exception. And as he put it, the exception must not be allowed to eat up the rule. Can it therefore be said to be fair, just and reasonable to impose a non-delegable duty of care where the claimant is a patient, but not one who is particularly vulnerable or dependent on the protection of the defendant from the risk of injury? It's unknown whether this is something that could be or will be challenged in the Supreme Court. I've looked online to see what is likely to happen with this case and whether there has been an appeal to the Supreme Court, and haven't been able to find anything. But nevertheless, we must deal with the ramifications based on the Court of Appeal's decision. The following steps, I would suggest, could potentially reduce the risk for a practice owner of a finding of non-delegable duty. Firstly, they could redraft their practice leaflets and website, ensuring that information provided to patients explains that associate dentists are self-employed, independent contractors, and are personally responsible for the treatment they provide. Secondly, they can ensure that all correspondence with the patient makes clear who the treating dentist is, and that the patient will be a patient of that dentist for the duration of their treatment. This includes ensuring that text confirmation of appointment state who the appointment is with, rather than stating the practice name. They can also ensure that the name of the treating dentist is added to the personal dental treatment form. Dental Protection have suggested that the name of the treating dentist could either be handwritten alongside the proforma number or added into the oral health assessment box, which sets out the care and treatment provided. Fourthly, where practices seek to transfer their liabilities to their independent contractors, they should ensure that they have appropriate indemnity provisions in their associates agreement to allow them easily to do so. This should be both in respect of the provisions relating to liability for the contractor's own actions, but also a requirement that the contractors hold appropriate indemnity insurance. They should also ensure that suitable provisions for regular due diligence are in place to ensure their contractors have sufficient insurance cover. Practice owners should also be aware that if there's no written agreement, they're at risk that one will be implied on a standard template BDA associate agreement. Turning to the steps that can be taken to reduce the risk of a finding of vicarious liability. Of course, Mr. Rattan was not considered vicariously liable for the actions of the associate dentists, owing to the freedoms that they had in the practice. But nevertheless, the finding was specific in that case. The judgment, in my view, only sets a very limited precedent for vicarious liability claims, and you still see this pleaded and pursued by claimants. It does strike me, however, that on the issue of vicarious liability, the restrictive covenants in the associate agreement referenced by Lord Justice Beam in relation to non-delegable duty of care do not appear to have been considered in the analysis of whether the relationship between the practice and the associate dentist was akin to employment, or whether the associate dentists were carrying on business on their own account. As such, some commentators have said that the true position of the associate dentist may be closer to true employment than is recognised in the judgment. And that may be a point that carries some force in later cases. But nevertheless, the following steps set out on the slide could potentially mitigate the risk of a finding of vicarious liability. Contracts, well, practices need to check whether any clauses suggest a relationship akin to employment. For example, if the following are stipulated in associates' contracts, it's less likely to be considered akin to employment. That associates are responsible for their own tax, national insurance contributions, that they can work for other practice owners or businesses if they wish, that they do not receive sick pay or pensions from the practice owner, they can choose which laboratories or which consultation rooms to use, that they're responsible for their own clinical audits of their patients, that they have complete clinical control of the dental treatment provided to the patient and are responsible for their own standard of work, and that they pay for their own clothing and non-standard equipment and materials. Secondly, indemnity provisions. Practices need to ensure that contracts contain the requirement that associates hold their own indemnity. They should also ensure that as a practice owner, they have additional protection against vicarious liability and non-delegable duty of care claims brought against them relating to treatment provided by associates. If their business is operated through a limited company, it's important to note that the company as an entity may need separate protection. A minor point, but associates should hold their own business cards with no practice branding. In practical terms, they should retain up-to-date contact information for all clinicians, as many of them don't, including at the point an associate leaves, so that the associate can be contacted in the event that a claim is brought against the practice. Against the background of this case that we have been discussing, how does this impact on your decision as a practice owner to seek contribution from your associates? And if you are acting for one of the associates, how does this case impact on your defence strategy? So what I plan to look at is in what circumstances and by what mechanism should you as a practice owner seek contribution from your associates? And if you're on the other side of a contribution claim, what tactics can be adopted to resist a claim for contribution or indemnity? Where the claimant, let's call them C, has sued a practice owner, let's call them D, and D wishes to seek contribution from his or her associates, let's call the associates A, who provided the treatment. Should this be done within the main action or outside within the 2-year time limit? Well, this decision will always be case specific. But the following general principles apply. There's always the advantage that D can defer the defence in the main action to A and potentially reduce the cost. This particularly applies to the breach of duty defence, where D requires the input of A to comment on the treatment provided. In many cases, D can, in theory at least, allow A to take on their defence of the claim. In cases where C has not sued A, the litigation risk is increased. If C cannot show non-delegable duty or vicarious liability, the claim against D fails, and C is potentially liable for A's costs in addition, although Quox is likely to apply, on the basis that D would never have sued A if a claim hadn't been brought against them. And joining A as a Part 20 defendant increases the prospect of some firms of solicitors taking a decision to join A as second defendant. So this, therefore, increases the potential for discontinuance against D. If A is good for the money, there's no advantage to continuing to pursue D. However, in cases where breach of duty is unarguable, is it worth an additional claim against A in the main action? Well, there's obvious disadvantages to that. The costs increase unnecessarily. You run the risk of two different defence organisations in conflict with each other, or indeed with two of the same defence organisations in conflict with each other. In these cases, there's always advantage to making an early competitive Part 36 offer and seeking contribution off stage, as it were. And on that point, crucially, the fact that D chooses to settle doesn't bar him from seeking a contribution from A, provided that his settlement was bona fide. This means that D is entitled to settle claims in good faith that he may not accept, but in respect of which he recognises a potential liability, without concern that doing so will provide A with a defence to a claim for contribution. This means that he will be found by virtue of the Contribution Act to be liable, assuming that the factual basis of the claim against him could be established. So what this means is that if D settles a claim which was flawed as a matter of law, for example, in a claim in negligence, he owed C no duty of care in tort, thus meaning he had no liability to C, he can't successfully seek or recover a contribution from A. So it will be seen immediately that it may not be worth pleading and defending a hopeless case on vicarious liability, non-delegable duty of care. If you subsequently seek contribution or indemnity from A is perfectly entitled to argue that on D's case, they settled a claim that was bad in law, and as such, by operation of Section 1.4 of the 1978 Act, they cannot seek contribution. However, the fact that there's a factual dispute between D and C before compromise, for example, over what D said or did in the performance of an existing duty of care, that doesn't bar a contribution. In IMI PLC and Delta Limited, a unanimous Court of Appeal reiterated the correct approach where the defendant has raised a collateral defence, and it held that Section 1.4 of the Contribution Act meant that D need only show that he would have been liable to C, assuming that C would have established the factual basis of a claim against him. So in contribution proceedings, the court therefore proceeds on the assumption that the underlying claim was made out if it discloses a reasonable cause of action, such that the defendant in the main proceedings would have been found liable. However, there's no point seeking to test whether D in the main proceedings was negligent, because the court, when evaluating contribution proceedings, proceeds on the assumption that the underlying claim was made out. Any other approach goes against the policy of the legislation in seeking to prevent the relitigation of previously settled issues. And there's a recent case of the Court of Appeal called Percy and Merriman White, which deals with that. The real issue for you is whether A is liable, and if so, what is the extent of their contribution? So in reality, as a Part 20 defendant or third party, the only defences that you're likely to have will be your liability defence, if that applies, a Section 1.4 defence, if the defendant has settled the case whilst maintaining that the claim was bad in law, and finally, the extent of any contribution. Although unless the defendant treated the claimant themselves and the contract or service agreement is unambiguous, you may struggle to resist a claim for a full indemnity in those circumstances. So all this is to say thank you very much for your attention, and please do get in touch with me if you would like me to forward on the paper that I've discussed. Thank you very much and enjoy the rest of your day. Goodbye now.